Okay, so I think I'm going to get started. I usually start kind of slow just because you know how it goes, people trickle in and out. I know a lot of you, but for those of you who don't know me, I'm Sarah Bonnell. I'm one of the advisors in the Global Engagement Office. I work with the international students and our scholars, and I joined Santa Clara as an advisor in I guess October of 2014. So some people that are on STEM right now, I don't know and I've never met before, but most of the current students and most of the people that are on OPT or STEM OPT I've interacted with in one way or another. And this is a STEM OPT Townhall Meeting. And so if you want, you can sign in and submit questions using that URL right there. You've already probably RSVP'd, and a lot of people did submit questions via the RSVP function, which we will be addressing today. And so I'm going to just go right on ahead. I'm using a microphone, which feels really weird to me. If you've seen me present before, you know I have a very loud voice. So if it gets too loud, I'm trying to talk like quiet. This is my quietest talking. So if it gets too loud, just let me know to quiet down. And I might take it off if I get too uncomfortable. All right, so I'm going to go ahead and get started. Like I said, this is the STEM OPT Town Hall Meeting. This is the third of 3. We are going to be putting these slides online. They're actually, a version of them is up already. And then we're also taping it, which is why I'm wearing a microphone, so that we can put it online for people that are not in the area or couldn't make it to this or another one. The first thing I'm going to do is just take a quick kind of census to see who's here so I can tailor as much as possible of the presentation to your specific needs. And then I'm just going to go into kind of what this is and what STEM extensions are. I'm going to give you a summary and an analysis of the new regulations and outline how it's going to impact all of our students and alumni and how we're going to manage the workload that is going to be caused by this new regulation. And then there's going to be plenty of time for discussion. Up in the front, on the front row, because nobody ever really sits in the front row typically, I've got scrap paper and some pens for you to take notes. I want you to hold your questions to the end so that we can make sure to get through all this stuff as fast as possible. I also have Global Engagement Office stickers. We've got some keychains and some caramel apple pops, which are my favorite. So feel free to come on down and get some if you want them. And don't be shy. All right, so one last kind of technical thing before I get into the census. This is a town hall meeting, so the point of it is for me to give you some information and for us to discuss it. This is not a workshop, it's not technical in nature. I'm not going to tell you how to fill out the new I93 training form or what checks you need to submit. I will probably answer technical questions, especially in the question discussion section. But the main point of this is to familiarize people with the new regulation and to outline how it will impact our university and to discuss how it will impact our university. We will be having STEM OPT workshops in the sense of how do I fill out this form, when do I submit this form, where do I mail it to, very technical workshops. They're going to be held once a month, and they're starting in April. They're going to be in the evenings. We are going to be taping them and putting them online to try to help everybody understand how to fill out the new forms and the new documents that are required. So that's kind of the difference between a town hall and a workshop. All right, so who here is a current Santa Clara University student, a current student? Great. Of the current students, there's a lot of you, who's graduating in the June term? And who's graduating after June? Who just got here? Anybody just got here? All right. Do we have any undergraduate students or alums in the crowd? Undergraduate level? Did you do your undergraduate degree at Santa Clara? No? Okay. And who here is on OPT, the 12 months of OPT that you get after you graduate? Great. And who here is on STEM OPT, the 17-month STEM extension? Excellent, thank you. Okay, very good. So there's more current students than alumni, which is surprising and was not the case at the last town hall. Obviously OPT, STEM OPT and OPT really affects alumni quite a bit, but current students will be happy to know that this is basically a get your cake and eat it too situation. So current students, people who have not yet graduated, really won't be impacted negatively about this law at all, right? By the time you get around to filing a STEM extension, you're going to have, you know, somebody else will have gone through the growing pains, and it'll be very easy and seamless. So given, you know, who we have, I'm going to talk just quickly about what exactly is a STEM OPT extension. We're using a lot of acronyms here, which is pretty typical for immigration. So the STEM extension, STEM, is science, technology, engineering, and math, right? So the fields that are related to science, technology, engineering, math, that's going to be all of our engineering graduate students and undergraduate students, all of our undergraduates that are in the College of Arts and Sciences in the sciences, like math, biology, and then MSIS in the graduate business program. And that pretty much encompasses everyone. People that are in the law school, people that are in the School of Counseling, Psychology, and Education, will not necessarily benefit, although there are some new provisions that might help them benefit depending on their background. OPT, optional practical training, is a type of work authorization that's given to graduates of academic programs. So you get 12 months of OPT after you complete a degree, and then if you have a qualified STEM degree, you get an extra, well, it used to be 17 months, but now pretty soon it's going to be 24 months, right? So it's an extension of the OPT that everybody gets, right? And I think it's really important, and it's quite noteworthy, at least for me, that OPT is not a work visa. It's not particular to an employer. Everybody who's on OPT knows that already. Hopefully people who are graduating in June also know that because they've been to an OPT workshop. OPT is a continuation of your F1 status. So while you're on OPT, you continue to be sponsored by Santa Clara from an immigration standpoint, which means you continue to interact with us and, for example, attend our town hall meetings when the law changes, right? We're your source of information from an immigration standpoint because we're your immigration sponsor, not your employer, not the company that you work for. And I think that's really important, and you'll see kind of why going forward. All right. So I think most of you already know this, but how many people have received emails about STEM OPT updates from our office? Good. I feel like everyone should have their hands up. So we've been sending out emails and alerts about STEM OPT updates and immigration regulation change since, well, November of 2014, right? So we have an entire website that's dedicated to STEM OPT regulation change, and we've been updating it pretty much incessantly for the last several months, every time there's been any changes. Most of you probably know this stuff already, but I'm just going to kind of hit the high points to let you know the context of this regulation that's just now coming out. So STEM was created in 2008 when George Bush was president. In 2014, there were a bunch of calls for reform and review by Congress to look into possible abuses of STEM. And then at the same time, President Obama announced executive action for immigration reform, and in that announcement specifically called out international students and said that he wanted the Department of Homeland Security to expand and enhance opportunities for international students to engage in practical training. So everybody got really excited about that, but there wasn't a lot of information. Expand and enhance isn't much to go off of, right? So some people were like, oh my gosh, OPT is going to be expanded to 5 years. And then other people said, oh, they're going to expand STEM to count every degree. Nobody really knew what it meant until quite recently. And then last summer, in August of 2015, there was a massive, major court decision that came out that was in a case that's actually ongoing and still on appeal that basically invalidated the STEM regulation. What the case said was that when the STEM regulation was created back in 2008, the government didn't follow the correct procedure in creating this regulation, and therefore the regulation itself was invalid. The judge gave the government, the Department of Homeland Security, time to fix it. It wasn't enough time. They had to ask for extra time. And there's still an appeal going on about a technical matter, and if anything changes, we'll certainly let you know. But that's just kind of one more point. And then In October, the draft rule was published, and then the final rule was published in March, which is when you started hearing from us really aggressively, publishing tons of information. And then the new regulation is going to go into effect on May 10th. All of this is to say this shouldn't be new. You've definitely been hearing about it if you read your emails, which, not everybody does. The one thing I want to point out about the new regulation that's going to be really important and is going to impact all of our lives the most is that the new regulation calls for and creates a new training plan for STEM OPT students, and that is the Form I93. This is going to be a really important form. It's quite technical. Towards the end, I'll actually pull up the PDF of it and show you what it looks like. It requires information about your job and about what you're doing and about what your goals are and how it ties to your academic degree. It also requires that your employer sign it with attestations, and it includes evaluations that go on. I'm going to talk in more detail about it. I'm not going to talk to you about how to fill it out because that's what we're going to do in our STEM OPT workshops, but I want to point it out now because I am going to refer to it multiple times in the following slides. And it is kind of the big change other than the 17 to 24 month change. So I'm just going to go through a couple slides that talk about the analysis of the regulation and compare it to the old regulation. Obviously the old regulation had STEM OPT, the extension that you get after OPT if you have a qualifying STEM degree. It was 17 months, now it's 24 months. With a possible 7-month extension for people who are currently on STEM OPT that's valid for 17 months, and I'll talk about that in detail. It also expands the amount of time of unemployment, so if you used to get 30 extra days of unemployment on STEM OPT plus whatever you had left from your OPT period, this time you'll get 60 days plus whatever you have left for a grand total of up to 150 days across 3 years. One thing that's quite interesting about this regulation is that it actually expands the number of times you can use OPT in your lifetime. So it used to be you could only get the 17-month extension one time. Now you can use it twice. So for example, if you got a bachelor's degree in the STEM field, you could do a year of OPT, 2 years of STEM OPT, and then if you go back and get a master's degree in the STEM field, you could again do a year of OPT and 2 years of STEM OPT. And so that's quite beneficial to many international students that pursue multiple degrees in the US and to people that are considering going back to education after working or after being outside the country for a while. In the prior regulation, there was no provision about tacking your STEM extension onto a previous degree. This is kind of a weird technical point, but it's a nice one, and it's one that we're pretty excited about. I'll give you an example. If somebody goes and gets a degree in biotechnology, right, biology or bioengineering, and they, say work on OPT for a year, and then they go back and they get a master's degree, but their master's degree is in, business administration, an MBA, which is not a STEM field, of course. An MBA is not a STEM qualifying degree. They can do OPT on their MBA, right, because it's at a different level, bachelor's in bioengineering, a master's in business administration, 2 different levels of OPT. But in the past, you've never been allowed to do STEM OPT off of that MBA. In this situation, because somebody has a qualifying STEM-related US degree, that's a previous degree, they can actually tack their STEM onto their MBA, right? So if you happen to have a qualifying US degree that's in a STEM field and you've not used a STEM extension previously, or even if you have, check in with us if you think this might benefit you. And there actually are quite a few students at Santa Clara right now that this does benefit, including, for example, we have some people in the law school that do, like technology law and have undergraduate degrees in technology fields but are getting JDs. JDs are not typically STEM qualified, but they'll be able to get STEM extensions because of their undergraduate degrees that are in technology and engineering fields. So that's pretty cool. There was a lot of talk about cap gap. Does everybody know what cap gap is? Does anybody know what cap gap is? I know one person does because we've talked about it. So cap gap, and I can talk a lot more about this later, cap gap is an automatic extension of your OPT, work authorization, from the day that it expires through October 1st, when you are the beneficiary of an H-1B that has been selected in the lottery. So if you're running out of your OPT or your STEM OPT time, and your OPT expires, say, on June 1st, your H-1B is filed on April 1st, your OPT expires on June 1st, how do you get from June, when your OPT expires, to October, when your H-1B would take over? Cap gap is how you get from June through October. This is an important thing that's benefited many people. It was in the 2008 regulation that was invalidated. It was in the draft regulation that we saw, and it is still in the new regulation. So cap gap remains, it stays the same, there's no changes there, which is good to know. And then the old regulation had a provision that benefits OPT students. So this is not relevant to STEM OPT, people applying for STEM. This is relevant to people applying for OPT, completing their degrees. The old regulation just had a little provision in there that said that you were allowed to apply for OPT up to 60 days after your program completion date. Now, any of the people that are graduating in June, have any of you been to an OPT workshop before? Yeah, a couple of you. So you probably, if you've been to an OPT workshop recently in the last couple of months, you've seen that we've been very, very aggressively telling you, do not file after your program end date. Do not file after your program end date. Because this provision was in the old regulation, it was not in the draft regulation, and then because of public comment, it was added back into the new regulation after the draft period and for the final. So it's stable now, but for the last 6 months, we've not been sure whether or not this was going to be stable, and so we've been really aggressively advising students not to file after the completion of their degree. It is possible to file after the completion of your degree. Obviously, we don't recommend it. If you have questions about that, you need to see an advisor about OPT-related stuff. Moving right along. So I think that it's important to kind of highlight some of these minor changes, right? So the filing requirements aren't actually, in some ways, they don't seem that different, right? If you look at one to the other, it's only one thing that changes, right? The I93 training plan, whatever, it's just an extra form, who cares? But it's important to note sort of what that extra form entails and how much work it requires. It's not going to be by any means the same type of application. So if you've applied for OPT, or if you've applied for OPT and STEM OPT, you know the OPT application, it's not that bad, really. You know, it's an I-765 form and it's copies of some documents. It's not that big of a deal. But the I-983 form requires quite a bit. It requires employer attestations and certifications. It requires you to really sit down with your employer and think about your job and your training progress and what it is that you're trying to get out of this training opportunity. And so it is important that people not think that they can just process these STEM extensions in a very fast way, because it's going to take, it's a lot of moving parts, right? It's totally possible to do it, it's no problem, but it is going to take a while for everyone to get used to it. And then I think this is a curious thing, because there's so many different sort of government agencies and sub-agencies, right? So everybody knows the Department of Homeland Security and the Department of State. Then underneath that you've got, you know, USCIS, who issues the EAD cards. They actually create those cards. That's who you write your checks out to. And everybody's interacted with CVIP and CVIS before. They're the ones that have the system that makes the I-20s, and we track, you know, your not location. That sounds super creepy. We track where you physically live and your employers through CVIS. But this actually brings another agency into play, and that is Immigrations and Customs Enforcement. So Immigrations and Customs Enforcement actually runs the CVIS system, but you've not really interacted with them directly. The I-983 is their form, and they're the ones that control it, and they're the ones that provide the guidance on it. And so it's just kind of yet another government agency that we're dealing with, which is totally fine, because our office is very used to dealing with government agencies, and some of us really like it. So this is kind of an outline of what's going to change. Again, I refer to the completion of the I-983 training plan and attestations. And then one thing that's really important is that students are not just going to have to report to us when they change their company. but they're also going to have to report what are called material changes. So material changes are anything that's on that I93 form. If that changes, you have to tell us, and you tell us by submitting a new form, which requires new signatures. And so not only do you need to tell us, like, when your company changes, you quit Google and you go work for Apple, but if you work for Google in Mountain View and Google moves you to Arizona, we need to know about it. If you are working for Google as a software engineer and they promote you to a senior technical lead, we need to know it. If your pay gets raised or cut, we may need to know it. If your hours get raised or cut, we may need to know it. And so it's important to note that there's going to be a lot more reporting involved, a lot more interaction with us involved, which makes sense because you're under Santa Clara's immigration sponsorship, so of course you're going to continue to interact with us, but it's quite a bit more interaction than at the OPT level, and that is intentional. That was written into the law intentionally. And then in addition to the check-ins that we do every 6 months, so people who are on STEM OPT have received emails from us kind of irregularly, sporadically. It's actually every 6 months, which is quite regular, that just ask for a quick check-in. Where are you working? Where are you living? We'll keep doing those, but you also have to submit a self-evaluation signed by your employer at the 12-month and the 24-month point, right? So again, more paperwork, more compliance, more submission, and more oversight, more protection, more evaluation. Because remember, this is optional practical training. It's not optional practical, take a job and work 70 hours a week. It's optional practical training. You're supposed to be being trained and mentored and engaged and learning, and you're connecting back to your academic program in an effective way, meeting, learning outcomes. And so that's really what this, the government doesn't have a way of sitting down and talking with you about your learning outcomes. And so the only way the government knows to connect with you on these issues is by having you fill out extra forms, basically. It's like being in love with a robot. All right, so I want to outline the employer requirements, not because these are your requirements, but because it's important to understand how this is going to affect your employment relationships, particularly if you work for a smaller company. So my expectation is that if you're with a big company, they're probably going to be paying their attorneys to fill this stuff out. And I know immigration attorneys from my previous life as an immigration paralegal that are quite excited about this new regulation because all of the extra forms they get to fill out and money they get to charge. And there are lots of companies that just kind of think of immigration as part of their annual expenditures, and they just kind of set aside money to pay immigration attorneys to fill out these forms, right? But if you're working for a smaller company, it might be a conversation that you have to have, with a manager, with human resources, with a legal counsel, with kind of other higher ups at your company, because the forms ask for quite a bit of information. So the attestations that the employers sign include confirmation that they are not displacing any U.S. workers, that they are paying you a wage that's commensurate with other U.S. workers in similar jobs, including what they offer you for benefits, what they offer you for PTO. And this is really important because this protects you and it protects the U.S. workforce as well, right? So you hear a lot if you watch the news, and I actually really hope that you don't watch particularly the political news because it's pretty embarrassing and I feel very awkward about it. But if you watch the news, you hear a lot about like, oh, foreigners stealing American jobs, and kind of what the conversation is about at a very high technical level is about wage undercutting and the idea that companies can bring international people in and they don't have to pay them benefits, they don't have to pay them PTO, and they're just paying them a base wage that maybe even is less per hour. U.S. workers have to be paid benefits, and they have to have health insurance, and it's just more expensive to employ them in general. So this benefits two people, right? This makes sure that you're getting a fair wage, which you've always been entitled to. It's against the law for a company to discriminate based on your immigration status or nationality, so it would be absolutely unlawful for a company to say, I'm going to pay, Tom Jones, American citizen by birth, $100,000 and give him 2 weeks of PTO and full medical coverage, but I'm going to pay this person from another country, $95,000 a year, and I'm not going to give him any medical benefits because I don't have to, because he's not subject to the Affordable Care Act or whatever. That's not legal, and This just further solidifies that. But when you're asking employers to sign all of these things that say, I won't do this, I won't do this, I promise to report when this person leaves the company, I promise to report material changes, because they also have to report material changes. Sometimes companies get a little weird about it. They're like, what exactly are you asking me to do here, right? Because OPT, it used to look to companies like kind of free work authorization, right? If an H-1B is in this crazy lottery and it's super hard to get one, and you have to pay an attorney to fill it out, and then you have to pay the government thousands of dollars in filing fees, it's quite expensive to get somebody an H-1B. It's not expensive to hire somebody on OPT because you can just hire them outright, right? Because they have a work authorization card that's sponsored by their university. This doesn't cost the employers anything other than compliance and the requirement that they actually comply with the regulations in a very firm way. And so I think that's really important to keep in mind as you're starting conversations with employers about your immigration status and what you need from them to support that status. The one other thing I'd like to point out is what's called random site visits, and that is that anybody who's been working for a company on OPT has already been subject to the possibility of a random site visit and the possibility of the government showing up at their job and asking to see them or talk to them. This regulation actually kind of funds it and puts it very clearly in I wouldn't say the forefront, but in the regulation, that this is not just a possibility, but that this will happen. Not on every single case, not in the majority of cases. They don't release numbers on how many people they actually site visit usually, but this is something that definitely has employers shaking in their boots. Employers never want the government prowling around on their facilities, premises, and it's something that really, really upsets people when they start hearing about it. It's frankly not that big of a deal, particularly if you do what our guidance is going to be, and that is instead of just turning in your training plan to our office, you should keep a copy and the company should keep a copy. And if the employers actually follow their rules, it's not a big deal, but it's something that can make people quite nervous. And then the one last thing I want to say about employer requirements is that our office is working internally and then also with the various career and career management centers on our campus to try to come up with some best practices about how we can appropriately and effectively communicate with employers about what their rules are. So if you had asked me about a month ago how we interact with employers, I would say, first of all, quite rarely, right? So there is a rule right now in the 17-month regulation that employers are supposed to report whenever an employee that's employed on STEM OPT leaves their company. I've worked at Santa Clara since October of 2014. I've never once had a company call me and say, so-and-so left and doesn't work here anymore, even though I know people change companies on STEM OPT, not all the time, but pretty frequently. So some of this stuff is not new. It's just that the employers weren't aware of the regulations before and need to be aware of it now and are actually signing that they're aware of it now. So we're trying to come up with some guidelines on how to communicate with them and also how to respect your privacy and also how to make sure that our office is following the university's regulations and rules as well. So I think we'll probably eventually put together an employer resource on our website that outlines some information for employers, similar to this but with much more detail that will hopefully be useful. And then I think the other thing is that while you do have to get the employer's signatures on the I-983, and you actually are being instructed by ICE to collaborate with your employers on filling it out, the way that the regulation is written is that the burden of filling out this form is on the student. The responsibility to fill out the form, the responsibility to collect the form, the responsibility to submit the form to our office is all on the student. And so you are going to be the primary actor here, which is important because, again, it's not a work visa that belongs to an employer. It's an F1 student visa sponsored by Santa Clara, but it's your status. So you're going to be playing an active role in maintaining it and keeping it. All right, so a lot of this stuff might seem pretty obvious, and I know I've kind of hit this point quite a few times, but I want to just make it sure that it's quite clear that we're partners in the compliance of this regulation, and we're partners in this process, which means that not only are you required to do new stuff, but we are required to do new stuff. So we have to figure out how to talk to employers. We have to figure out how to talk to alumni. We have to develop all new workshops. We have to manage a huge influx of cases in the next 6 months. And we have to really work with the university to help everyone understand what it means to sponsor someone on an F1, right? So a year ago, when you invited, when Santa Clara admitted an international student, what they were agreeing to is the duration of your program, which in most cases is 2 years for graduate students in the STEM fields, plus whatever you had for OPT, which was anywhere from 12 to 29 months. Santa Clara's not just agreeing to that anymore, right? They're agreeing to anywhere from 12 to 24 months, 32 months, there we go, 36 months, there we go, last one. I'm not from a STEM field. I have a philosophy degree, so I do not know how to do math or type. So the point that I'm making is that Santa Clara's compliance is increasing, our workload is increasing, but also our commitment to international students and alumni is increasing. And it's pretty easy to help a university understand its international student needs when the international students are here on campus taking classes and eating in Benson and working in the library. It's a little bit harder to help explain to campus stakeholders the importance of an international student and alumni community when the alumni are working off campus, sometimes not even in this area, mostly in this area, but sometimes not. And so that's one of our roles, is to help the university understand that international alumni continue to be sponsored by Santa Clara, and they're continuing to need resources like workshops and career services and assistance and compliance and all kinds of stuff. So that's what we're working with here. So I've talked about kind of the rule and an analysis of it, and I can go back into greater detail later. I just want to reiterate for people that came in a little bit late that I have notes up front that you can use to take notes and write down your questions if you have them. There's some swag, some business cards, some Santa Clara University Global Engagement Office stickers, there's caramel apple pops. Feel free to come down if you want anything. And then we're going to have plenty of time for questions. There's actually not that much more left to get through, and so don't worry at all. So I've talked about the analysis, and now I'm going to talk about kind of the impact and how this will impact various groups of students and our office and the university. So Santa Clara University, as of last Wednesday night at 9 o'clock when I was writing this up, had about 730 active international students, and 70% of those students are in STEM fields, right? So the majority of those people are going to be eligible for not only the 12 months of OPT, but the 24 months of STEM OPT. Many of you, some of you, not many of you, some of you are sitting in the room today, right? So I'm talking about the active students, right? And then we also have 480 alumni who are actively engaged in OPT and STEM OPT. Over 80% of those students are in STEM fields, right? So it's not that surprising that people who are not in STEM fields don't stick around as alumni sponsored by Santa Clara for as long as people who are in STEM fields, because if you're not in a STEM field, we sponsor you for maximum 1 year after graduation, whereas if you're in a STEM field, we sponsor you for 29, now 36 months after graduation in some cases. So our office is going to be processing over 500 OPT and STEM OPT related cases in the next 6 months. That's a huge caseload, and several, well, I would say about 150 or more of those cases are cases that were created by this regulation, in the sense that it's extra work that we wouldn't have otherwise had to do. So of course we knew that about 200 people were, more than 200, about 250 people were going to be completing their degrees in June. We can tell when people are going to be graduating. But And of course, we knew who was going to be, finishing your OPT and applying for a STEM extension for the most part. But people that are on STEM extensions currently that are eligible for an extra 7 months, that's a third STEM extension that we didn't necessarily know was going to happen until this new regulation was published. Now, we've been modeling and planning for various things for quite some time, but what I'm going to talk about in the next couple of slides is how are we going to manage that workload? How are we going to manage 550, OPT and STEM OPT applications in the next 6 months and make sure that nobody misses any deadlines and make sure that everybody gets their full benefit and make sure that everybody gets their questions answered. And then we've of course talked about the impact to employers with regards to enhanced compliance as well as enhanced access. So for current students, this is going to be the easy one. Like I said at the very beginning, you definitely get to have your cake and eat it too, right? So you're going to get to benefit from this regulation. Yay! You're not going to have to deal with any of the transition, is what the government's calling it. So you don't have a case that's in transition. You don't have a pending STEM application. You don't have a STEM application that's going to need a mini extension. So you really don't have to do much other than just follow your path, right? Complete your degree, apply for OPT. We recommend that you do it as soon as possible, up to 90 days before you complete your degree. If you have a STEM qualifying degree, you will be eligible for the 24-month extension, and you'll be able to file that 90 days before your OPT expires. By and large, we don't need to do any personal or private advising with you on this topic because one, you're focusing on other things like applying for OPT and completing your finals and graduating on time. But two, it's going to be an established process by the time that you get here in a year or more. And so you really have the best of both worlds. If you are in one of two situations, I do want to see you for personal advising. If you think that you qualify for a STEM extension based on a previous degree, right? So if you're in that case where you have that bioengineering degree at the undergraduate level and you're getting a JD, I do want to see you for advising. And if you have been granted STEM OPT before, based on a prior degree, I also want to see you. We can do it real quick, but if you're in one of those two kind of unique situations where you're benefiting from a small provision of the new regulation, we want to interact with you. Otherwise, we want you to focus on completing your degree, applying for OPT, and moving through the process at a normal rate so we can also help other people. Like, for example, other students, like current OPT participants. So we do have quite a few current OPT participants here in the audience. How many again? Raise your hand if you're on OPT right now. All right, sweet. First of all, you need to keep working and you need to continue to report changes to your employment, employer, or your home address to our office using our portal or eCampus for your home addresses. I am in the process of, well, I've actually completed the analysis of all, I've analyzed every single one of our F1 records to see who is impacted in what ways, and I'm in the process of drafting customized emails to all of you. It's not, they are customized, but I'm not like writing each one by hand. We are using mail merge, but you're each going to get an email that specifically outlines exactly what you need to do and exactly when you need to do it. And when you need to do it is going to be the critical part for you. So you're going to need to plan to attend a STEM OPT workshop or watch one online so that you know how to fill out that training plan. So I want you to do that as soon as possible, but at least a month before your OPT expires. And then I think it's really important to know, and I'm trying to say this as many times as possible and as calmly as possible, and I want you to all be confident in this. We usually support students filing as soon as they're eligible, right? So 90, 120 days before their OPT expires, 90 days before their OPT expires. Because of our workload, we're not going to be doing that. We're going to be managing our workload aggressively so that we're helping people in advance of their expiration, absolutely, but not necessarily 90 days before their expiration. And I want everybody to really understand that as long as your STEM extension is properly on file before your OPT card expires, you are allowed to keep working. If you or your employer have questions about that, I have a template email I will send you that clearly outlines the exact regulation that says that this is allowed, as well as an FAQ from USCIS that explains why it's allowed, as well as a list of the documents that you will use to prove to your employer that you're allowed to keep working on your I-9 form. So this is absolutely stable, codified in regulations. This is not like some weird thing. This is 100% for sure, as long as your OPT extension, your STEM OPT extension, is on file with USCIS before your current card expires. 1 day before, 1 month before your current card expires, you are fine to keep working even after your card expires. So it's really important to me that students understand that so that you can feel secure in the plan that we've outlined in the next couple of slides. If your post-completion, so let's do a little visualization. Imagine your EAD card. Picture it in your head. Picture your expiration date. When does your OPT expire? Picture that in your head. If that date is on or before May 31st, I want to see you right now. I'm in communication with quite a few students that are in this situation, but if your OPT, your 12 months of OPT expires on or before May 31st, and there are less than 30 students in this situation, we need to file your STEM extension now under the 17-month regulation. We will not wait until the new regulation goes into effect. We need to file it now to make sure that you stay in status. If your card expires after June 1st, which is virtually everyone, we will begin processing your extensions on May 10th in an orderly fashion, and you will be benefiting under the 24-month regulation. And I'm going to outline explicitly when we'll see you based on your expiration in a couple of slides here. For the most part, I'm not providing personal advising other than the workshops and the personalized emails, so we are providing personal information, but I'm not going to do private advising appointments unless you benefit from one of those two unique provisions of law. If you're trying to benefit from a STEM extension based on a prior degree or based on your second STEM filing, I do want to talk to you. Otherwise, let's just go in the order that we are going to outline. Who here is on STEM OPT? Current STEM OPT participants? Yeah, a couple of you. Yay! Okay, so most of you, almost all of you, all but a very small number of you will be eligible to file for a 7-month extension, a mini extension. It's nice, a little mini one. We cannot start processing these until May 10th when the new regulation goes into effect. If your STEM OPT EAD card is valid after October 8th, we're going to be working with you on this 7-month mini extension. If your card expires before October 8th, you do not benefit from this regulation, and we should talk about what your options are. There are not a lot of them. So we'll outline when we'll see you, but these 7-month mini extensions need to be filed between May 10th and August 8th. And depending upon the date that your STEM OPT card expires, there may be a specific day that you need to file on. Again, I'm sending personalized emails that will tell you exactly when I'm going to see you in my office and how I'm going to help you most effectively. All right, does anybody in here have a pending STEM OPT extension? A pending extension? An extension pending with the government currently? Yeah, I didn't think so. I'm watching those cases like a hawk. They're really very particular. All right, so I'm going to not talk about this slide because this doesn't affect anybody. Okay, so this one's kind of hard to read. Again, we're sending this out to everyone. Again, we're putting this on our website. Again, I'm sending you a personalized email, so don't freak that you can't read it because it's kind of tiny. And I know there's other ones over here. But basically, this slide outlines who I'm helping when and how we're managing 550 cases over the next 6 months and how we're getting into a nice even flow of work where by August, we're just going to go back to normal processing. It's going to be nice and clean by August, right? So if you want, think about when your OPT expires and take a little look-see, and this explains when I'm going to see you for your appointment. I'm going to see everyone for their appointments at least 30 days before their OPT expires, right? At least 30 days before, which means you're working on your extension even before that, right? If I'm seeing you 30 days before, that means I'm issuing you your 24-month I-20 and you're filing your STEM extension at least a month before your current card expires. And this is, again, to make sure that there's no issues, make sure that everybody gets the full benefit with no gap. But we do have to build time in for the 30 or so cases that are currently pending and are going to be caught in the gap and are going to need another filing. We do need to make room for the people that need the 7-month extensions and have to file before August, or else they lose the ability to file that case. And so we want to help everyone, but we want to make sure that nobody gets left behind, which is the whole point of carving up our workload across multiple months. All right, I'm going to go back to this and I'll circle back multiple times on this to make sure everybody understands. And again, you will be receiving a personalized email that explicitly tells you what you need to do, when you need to do it. I was hoping to have those out today, but we're waiting on an approval to a change to the university website before I can send them out, because I can't link you to the STEM page until the STEM page has been approved and published. So just kind of quickly, if you want to know kind of what you can do to help this process along and make it as efficient as possible, please do a couple of things for me if you wouldn't mind. Please read the emails that I sent you. I know young people do not like reading emails. They want to get Snapchats and YouTube videos, which I'm going to give you some YouTube videos, but I'm not going to give you any Snapchats or Facebook posts, maybe a Facebook post. The point that I'm making is I work really hard to make my emails as short as possible, and trust me, I am a very verbose person. I can talk for hours on end without stopping, but I try to make our emails succinct and clear. Please read them and do what they say. There's literally nothing in the world worse than sending out an email that you feel is very clear and then having somebody reply back and ask you a question that is literally in the email that you just sent them. So please, please read our emails. Please do plan to attend or watch a workshop online. You are going to need to do this. The new STEM extension is nothing like the OPT application. This new training form, which I'll show you in a minute here, is not like anything you've seen before, and it's going to require you to do some extra work. So please be aware of that and go to a workshop to learn how to do it. We like to say one point of contact, one kind of contact. We get so many emails every day. We get so many phone calls every day. And unfortunately, when students send repeated multiple emails again and again and again, or when students email and then call and then leave a voicemail and then call and then email, it just creates extra work for us, and it's kind of frustrating, a little frustrating. We try to respond to emails within 2 business days. We don't work on the weekends. We don't work after 5 p.m. So if you send me an email on Friday at 7 o'clock, your first business day is Monday, because I don't work on Saturdays and Sundays, usually if I can help it. So if you send an email, wait for a response. Please do not send an email and then call and then email a different advisor and then call. We consolidate our emails, and so if you email multiple advisors, we know that you're doing it. If you call multiple advisors, we know that you're doing it. So yes, most emails should go to ISS and SCU unless you get a private email from me that like says, dear so-and-so, do such and such. Just communicate with the general account, because again, we pool our emails into that account. And then just remember that all STEM OPT advising is done by appointment. Do not come to drop-in advising hours about STEM OPT related questions. We will not see you. So please do not take time off of work and come to drop-in advising hours. Please schedule an appointment only. Yes, okay, sweet. So we're at the discussion point of the session. I think I just want to maybe to target the discussion at first, ask for specific questions, and then we can just open it up to the floor. So are there any questions from current students? Current students, do you have any questions? Yes?
I'm just wondering whether the appointment for OPT advising will be increased.
Yes, so the question was whether we are increasing our coverage for OPT advising, and the answer is 1, yes, we already have, and 2, it's really, really important to us. that we serve as many students as possible, as fast as possible. But it's also so important that students not abuse the OPT advising calendar. So those of you who are on STEM OPT that I worked with last year to file your OPT, you know that I had to schedule your appointments by hand, which meant I had to schedule over 300 appointments by myself, by hand, which took a lot of time and a lot of effort and a lot of energy. We've transitioned to an electronic calendaring system where you can select your own appointment, and it's awesome and it's working pretty well so far. We do have to expand and contract our advising hours to accommodate need over time. But our biggest fear is that students are going to abuse it and they're going to start selecting every single available appointment, or they're going to select an appointment and then they're going to check back every single day to see if we have an earlier appointment. If students do this, we will have to get rid of this calendaring system. So it's really important that students do exactly what we say. Select one appointment, stick with your appointment, do not cancel multiple appointments, show up on time, show up prepared, because we really don't want to go back to the old method of call the front desk, leave a message, wait 2 days, hear back what the opportunities are. Like, that's not functional for us either. But yeah, so anyway, to answer your question, we watch the utilization every day and we expand out hours. What happened in the last week is on Monday we're having our Spring International Student Welcome, so all the Monday appointments were canceled because we won't be in the office on Monday. And then on Wednesday, Susan Peters is going to be at the Jesuit School of Theology in Berkeley, which is part of Santa Clara, doing advising up there for the Jesuit School of Theology students. And so her OPT advising was canceled, but they've added in appointments to accommodate it. Yeah, does that answer? You good? Okay. Current students with questions. Current students, yes.
You did touch upon the concept of H1B being awarded to students during the CAP lab. What happens then? What if a student gets an H1B awarded and moves to H1B on October 1st?
Let's hold H1B questions. I want to get through some STEM questions, and then I'm more than happy to talk about H1B stuff for sure. And we talked about it extensively in the last town halls, and I'm quite happy to, but I want to get through STEM stuff first. Current students' questions about OPT and STEM OPT, yeah?
Yeah, I'm graduating in June, so when is the right time to apply for OPT? As of now, I don't have offer letter.
So to apply for OPT, you don't need an offer letter. You need to go to an OPT workshop. We have one on April 1st, and we have 5 more this term. And we cover this in the OPT workshops, but you can apply up to 90 days before your program end date, and we recommend that you apply as soon as possible. Questions from current students? Any more questions about STEM OPT from current students? Yes? Yeah, and that's, so your question, the question was, as per the new rule, the company needs to be e-verified for the STEM extension. How can you tell if the company is an e-verified company or not? So yes, so that's actually something that hasn't changed. That's actually the one thing that stayed extremely consistent, is that in order to benefit from a STEM extension, you need to be working for a company that's enrolled in E-Verify, which is a government verification system that pulls together information from a bunch of different government systems. E-Verify requires employer enrollment and quite a bit of compliance. The way that you can tell if your company is E-Verify is by, one, if you were E-Verified by your company when you got hired, then they're definitely an E-Verified employer. And it's possible they may have enrolled in it after you got hired. Like, for example, Visa just started being an E-Verified employer. The main way that you tell is you ask your company, and then the company provides you the information. The main issue that we kind of face is not knowing whether or not they are E-Verified, but when they are not E-Verified, how students progress. And that, we just do that in private advising. Yeah, absolutely. Okay, any further questions about STEM from current students? Moving right on. Questions about STEM from, yes.
So, what are the things that I not need to know about my company that in this new OPT rule, do I need to know that company follows this and that and all these things?
Oh, so your question is in regards to compliance, like do you have to monitor your company and make sure that they're actually filling out all their forms and reporting things to us properly? Yeah, this question actually came up in one of the other town halls too. So there are things that are listed as the employer responsibilities, and there are things that are listed as your responsibilities. You are responsible for your responsibilities. So, for example, if the employer is responsible to contact us when they fire somebody who's working on STEM OPT, the employer is responsible to do that. They are the ones that get in trouble if they don't do it. But you are also responsible to report your end date of employment. Almost all of the employer-related compliance things are also yours. The exceptions are that the employer cannot impact U.S. workers, like fire U.S. workers and lay them off to hire international workers. That would be an employer problem, not your problem. The wage attestation, obviously you have no say over what your wages are, so yeah. That's a good question. Do you feel like that was the answer? Okay, current OPT participants with questions. If you're a current OPT participant with a question.
So if I apply for a STEM OPT extension and I have to travel outside US, then what is advisable to do?
Yeah, so the question is about travel and STEM OPT. In order to get back in the country, when you're in a post-completion state, so after you completed your degree, you need to have a valid EAD card in your hand. So if your OPT EAD card is valid, you're pretty much safe to travel. If your STEM card is valid, you're pretty much safe to travel. But if you're in an in-between period, you may not be safe to travel. And additionally, we don't like, nor do we recommend that people travel while they have pending applications, because if you get a request for evidence, or if your case is approved while you're outside of the country, you will need to have your approval, your new card to get in, right? So they can tell if your case was approved, and if your case is approved, they want to see the new card. And if you get a request for evidence, how are you going to provide new pictures if you're in another country when the request for evidence is issued? So by and large, we don't like people traveling with pending applications, but sometimes it's possible. And you do need a valid card to get back in the country. If you are a person who is slated to do your STEM extension at a specific time, but you have travel that impacts that specific time, you should see us and we can make limited exceptions to see people like earlier based on travel plans that like can't do.
Okay.
Yeah. Yep. More questions from current OPT participants. Yes.
What if I change my employer when my STEM extension is pending?
Yeah, that is an intense question. You got me shaken. So the question is, what if I change my employer while my STEM extension is pending? Please don't, would be my answer. Yeah, I mean, in general, if you can avoid it, please don't, because we will need to collect an entirely new I-983, which will need to be submitted to the government while your case is pending, and it's quite hard to add documents to an immigration record while a case is pending. So if it's possible, we would want you to stick it out with your current employer until your card is approved, or transition employers before you apply for your extension. And the new employer must be e-verified as well, and must sign all the attestations. More questions, current OPT participants, people that are thinking about applying for the STEM extension. No more? You're all experts? Okay, what about people that are on STEM right now? You're on STEM, do you have questions? Yes?
So I'm on STEM OPT right now, and I am eligible for that 7-month extension.
Great.
So for the compliance with the new rule, is that compliance just for the 7 months or the rest of the STEM OPT period as well?
Yes, excellent question. I'm on a 17-month OPT right now. I am eligible for the 7 months. When do I have to start complying with the new rules? Is it May? Is it when I get my 7 months? It's when you get your 7 months. So once you start benefiting from the new rules, that's when you have to start complying with the new rules. If you stay on your 17 months and you opt not to file the mini extension, you don't want the 7 months because say your H-1B was selected in the lottery and will take over in October, then you will never have to comply with the new regulations.
So does that mean I don't need to maintain I-93 for the rest of my STEM OPT, which is valid for 17 months?
So if you stay on your 17-month STEM extension and you never benefit from the new rule, you don't even apply for a 7-month extension, you will never have to fill out an I-983. which is, you know, there is something to say about that because it's a long form. Oh yeah, I did say I was going to show you all what that looks like. This is the I93 form, and you can see that it has quite a bit of information about the student, and then there's your certifications, and then there's the information about the employer, which includes compensation. There's all their certifications, and then you have to put in information about the training plans, like the site. So there's the student roles, like what are you going to be doing, and there's all kinds of stuff about your goals and your objectives and how they're going to oversee you and supervise you and how they're going to make sure that you're actually getting something out of it. So this is a big form. It's a lot. We have a link to this on our website as well, just if you want to. I mean, I know I was like just scrolling through it really fast, but it's accessible on the web. And if you just type in Form I-983, like it'll pop right up. It's quite easy to find via Google. Okay, more questions just in general about STEM OPT. More questions from anyone about STEM OPT. Yes, in the back.
So the 7-month STEM extension, if someone gets, and that 7-month STEM extension falls into another H1B opportunity, and if that one gets waived, does that also have the caveat?
Yep, absolutely. The question was, if I have, if I do benefit from the 7-month mini extension, and the 7-month mini extension takes me through past April of next year, can I benefit from cap gap off the end of the 7-month? Yes, you can. As long as you have any kind of OPT, STEM OPT, mini extension, 24-month extension, 70-month extension, valid on or after April 1st, you can benefit from cap gap. Yeah, absolutely. Additional questions about the STEM regulation change? No? So we do have a pending question about H1B. So I'm so sorry, can you repeat your question?
So the question is, what if you're on OPT or on one of the extensions of OPT and you kind of benefit from an H1B and October 1st kicks in, then what happens? Like, because your status would change from an OPT to an H1B, so then do you just suddenly disappear and stop reporting, or like?
Yeah, so I think probably how I'll answer this question, rather than sort of repeating the question and answering it exactly, is just maybe talk just in general about what an H1B is and how it affects the F1 record, and then I can answer like more specific questions. So an H1B is a work visa. There are only 85,000 of them allowed to be issued every year, new ones. That doesn't count extensions and people transferring from one company to another. And because there are only 85,000 allowed, and way more than 85,000 people apply, we have a situation that is referred to kind of varyingly as a lottery or a cap or an annual numerical limitation or a congressionally mandated annual numerical limitation. But basically, suffice to say, there's too many people applying for too few slots, and how do they figure out who gets those 85,000? They do a random lottery. And that's what creates this weird panic about there not being enough H1Bs, and everybody freaks out around this time of year. And so there's, H1Bs are filed on April 1st, and then they accept all the cases for the first 5 business days, and then they sort them into 2 piles. They sort them into the U.S. Master's quota and the regular cap. If you have a U.S. Master's degree, they do your lottery first, and if you're not picked in that lottery, you go into the regular cap and you get a second shot at that lottery. And then they proceed, right? So there's kind of 2 important points in any H1B's career, and that is, number 1, the lottery, are you going to get picked or not picked? And then number 2, the approval, when they actually review the bona fides of the case and they make sure that the company is legitimate, the job is legitimate, the degree is legitimate, where they actually look at the case and adjudicate it, and it's either approved or denied. And so there is an important kind of note here, and that is most H1Bs are filed under what's called change of status. Change of status means that the H1B is filed in such a way that it goes through the lottery, it's selected or not selected. If it is selected, it goes through adjudication, review by the government. It is approved or not approved. If it is approved, then on October 1st, your status automatically changes from F1 to H1. The F1 status record is forcibly terminated by the government, not in a bad way, like you're not like, nothing bad happens. They just close your F1 record and your H1B takes over. The expectation in that case is that on October 1st, you are working for that company in that job in that location, exactly as filed in the H1B application, and you no longer benefit from F1 benefits like not having to pay FICA taxes, like having an unemployment period, like using your F1 visa stamp when you travel, like having a 60-day post-completion departure period, all of the things that make F1 so wonderful, like having an immigration expert that works for your university that you don't have to pay a bunch of legal fees to, for example. Then, at the same time, it's, you're working on an H-1B, it's a solid relationship with a company. I always say H-1B is like getting married. It's like putting a ring on it. If you're ready to commit to a company, that can be great. And it's like marriage in the sense that, not all marriage is permanent. It is possible to file for divorce. It's just quite expensive and hard to do and sometimes heart-wrenching. And so I think that H-1B can be right for some people and it can be not right for some people. It just depends, right? So far I've talked about H-1B change of status. And that's the common way things are filed. If your H-1B is filed as a change of status, you can call in the cap gap benefit that will bridge the expiration of your OPT to the initiation of your H-1B, right? So if your OPT expires, your H-1B starts, how do you get from one place to another? Cap gap. All of that is change of status. There is another way of filing H-1Bs, and it's called consular processing. Consular processing is filed on April 1st, the same way everything else is filed on April 1st. It's either selected or not selected in the lottery, the same way everything else is selected or not selected in the lottery. It's reviewed, its bona fides are reviewed, the same way everything else is reviewed, and it's approved. But when a consular processing case is approved, the approval notice looks a little different. It does not have an I-94 at the bottom of it that forcibly changes your status from, say, F1 to H1. Instead, it has like a little ticket almost, and it's a consular notification. It is something that you can use when you leave the country to go to a consulate and secure an H-1B visa stamp in your passport and then enter the country and show your H-1B visa stamp instead of your F1 stamp, and then be admitted in H-1B status, and that's when you're in H-1B status, right? So under change of status, you are in H-1B status on October 1st, assuming your case was selected and approved. In consular processing, your case is approved, and the first day that it becomes valid is October 1st, but the validity does not affect your current immigration status. You continue to be in F1 status. You continue to be working on your OPT or your STEM OPT or your 17-month mini STEM extension or whatever it is that you have. And you continue to benefit from F1 benefits like the unemployment period, the ability to change employers fairly easily, the possible STEM extension if you're on your OPT currently, the ability to use your F1 visa stamp to travel, the ability to benefit from the expertise of experts at your university. All of that stuff stays intact, right? Your lack of FICA taxes in some cases. And so there are great benefits to consular processing. The downside to consular processing is that it does not allow you to benefit from cap gap. Now, it doesn't matter if you're not at the expiration of your OPT, right? Cap gap is only important to you if your OPT or your STEM OPT or your current immigration work authorization expires between April 1st when your H-1B is filed and October 1st when the change of status approval notice takes effect. But if you are a person that, for example, is at the end of their 17-month mini extension and you need to get from June through October, you need cap gap. A change of status is what you have to have filed. The other downside of consular processing is that some employers are not super familiar with it or are not super comfortable with it. Because remember, I feel like consular processing, if H-1Bs are like getting married, consular processing is like a prenup. Like, some people say prenup and they're like, yeah, I mean, marriage is it's a financial thing. You gotta be protecting your assets. And some people, you say prenup and they're like, what, don't you love me? So I think the thing about consular processing is that some employers don't understand what it is. Some employers understand very well what it is and take it as a sign that you're not committed to that employer and you don't want to stay with that employer and you want to maintain your F1 status. There are benefits to the employers for you to stay on your F1. They don't pay FICA taxes in most cases, which means that they actually pay less taxes on your payroll. You are not on their H-1B tally, which means that if they're H-1B dependent, it keeps them from going over and having to pay extra filing fees. But and there are some companies like the Citigroup, for example, will only file H-1Bs for OPT and STEM OPT applicants that have extra time as consular processing because of the benefits to them. And because they're so tired of people, for example, traveling in the middle of an H-1B filing and messing everything up. But it's not a really common thing, and so it does require you to ask. And of course, the H-1B is an employer petition, which means that if the H-1B employer doesn't want a consular process, they're not going to consular process it. So that's kind of some general information. So as for your original question, which is what happens to my F1 when my H-1B is approved, the answer is it depends on what kind of H-1B was filed. If it was a consular processing H-1B, nothing happens to your F1. If it was a change of status H-1B, your F1 goes away, and you give up whatever OPT or STEM OPT you had left at that time. Is that good? Okay. More questions about STEM, H-1B, etc.? Yeah?
So obviously for the 7-month extension, you might wait after May 10. So, but before May 10, if someone changes his employer, does he still have to get into I-20? Because when we apply for the petition, we need to submit all the updated items.
So the question is about whether or not you need a new I-20 when you change your employer. And the answer is no, not necessarily. You do need to report changes of employer to our office. You had to do that under the old regulation. You will have to do that under the new regulation. But we do not have a habit of issuing new I-20s every time somebody changes companies, simply because that gives you yet another I-20 to carry in your big old pile of I-20s. And various people, I mean, I've had students that have 20 I-20s. I'm like, goodness gracious, where did you get all of these? And then I also have people that have, one. So I think, we don't want to add more to your paperwork pile unless we really need to. And so, you'll get one at your STEM extension, you're going to get another one at your 7-month mini extension. We're not going to add another one because you change employers, but if you need one for some reason, if you feel like you need one, you can request one, but you don't need one to file an H-1B. More questions? Yes?
Can I travel if my H-1B is filed under consular processing between April to...
Yeah, so whenever we're talking about multiple immigration cases being pending at the same time, we're going to want to touch base with everybody that's involved. So I can advise from the F1 perspective, the attorney that files the H-1B can advise from the H-1 perspective. But by and large, assuming that your F1 is stable and you have the documents required to get back in the country in F1 status, traveling when you have a pending consular H-1B wouldn't necessarily be a problem. I would still, in any case, recommend that you just mention it to the attorney filing the case, just in case they have any opinions, just in case the law has changed. My job is to advise on F, and so I don't keep up with H-1B laws the same way that I used to when I was a paralegal that was filing thousands of H-1B cases a year. So, yeah. Yes?
Whom do we report to during our CAP?
Still Santa Clara, you're still sponsored by, sorry, the question was to whom do you report during your CAP period? And if you're still in F1 status, it's still a benefit of your F1 status, and you still report to our office.
And it's automatic, right? So you don't have to file or
the question is if CAP is automatic. CAP is automatic, it automatically goes into your immigration record. We don't have to issue a CAP I-20, although some employers will ask for your CAP I-20 because of I-9 compliance and the need to have some type of a document that proves that you're allowed to keep working after your card expires. So we do have a CAP request form. We'll probably get it up on the new website in the next couple of weeks because it's that time of year. So, yeah. I'm sorry, you had a question and I
Say my EAD expires the 7-month extension on June 1st and I get to hear about my H-1B. So that would be my last chance to apply for H-1B, right? So in that case, I would not fall into CAP. So what will the situation be?
So the question is, say my 24-month extension or my 7-month mini, my last little drop of OPT, STEM OPT expires on June 1st, which is before October 1st when the H-1B would take over, and after April 1st when the H-1B was filed. But I don't know yet whether my H-1B was selected in the lottery, what's my situation. So there is a, CapGap actually has a couple of different little sub-provisions, and so for people who need to benefit from CapGap but do not yet know if their H-1B was selected in the lottery, we do what are called interim extensions. So we give you basically a mini CapGap extension that is valid for, I think it's 3 months, or until you find out whether your case was or was not selected. And if it was not selected, the CapGap benefit goes away once you find out it was not selected. For reference, you will know whether your H-1B was selected by June 1st. For sure, you'll know in May, and perhaps even earlier if it's premium processed. But what I said is true in any case. Yeah. More questions? H-1B, OPT, STEM OPT. What's my dog's name? What's my cat's name? Best friend's name?
You don't have a dog.
I do. I have two cats and a dog. I just talk about my cats all the time. And no, I grew up with dogs. And, yeah.
You're a cat person.
I'm an animal person. I'm an animal lover. Yeah. Yeah.
Can you change your job after H-1B?
So the question is whether or not you can change your job after your H-1B is approved. So there's a couple of facets to that question. One is after you're in H-1B status, or after your H-1B is approved, but before it goes into effect. So the first question is pretty easy to answer. When you're in H-1B status, you can change employers. Like there's some like urban legends that employers are like, going to chain you to a radiator and steal your passport, which they did used to do actually in the 90s. Not the radiator part, but the passport part. And no, they don't do that anymore. And if they do that, please, for the love of God, call the Department of Labor or me or the police, whichever one makes you most comfortable. But yeah, you can change employers when you're on an H-1B. It's just important to understand that when you change employers on OPT, you just change employers. When you change employers under STEM OPT, you just change employers. And when you change employers under the new STEM OPT, you change employers and you have to submit a new training plan to our office. When you change employers under H-1B, the new employer needs to file an H-1B on your behalf, and what that means is not that you have to go through the lottery again, but that they do need to submit a petition to the government. Still costs money, still costs an attorney to file it for them in most cases, and so it's not the same as changing employers on OPT, right? But it is possible, and you don't have to go through that crazy lottery again, by any means. The other question about can you change employers after your H-1B has been approved before your H-1B goes into effect is a little bit like there's a lot of sort of sub-questions there, and it would require essentially like a personal consultation with our office and with an immigration attorney to determine how you can protect your H-1B and you can protect your immigration status. We've had this happen where we had a student, we actually have this happen every year, but I had a student last year, it was like the worst case ever, who had not one but 2 H-1Bs filed on her behalf, not one but 2 H-1Bs selected on her behalf, which is sketch, y'all, and that's not fair because there's not enough H-1Bs to go around. So having not one but 2 is hoarding, and it's totally not acceptable in my opinion from a moral standpoint, but that's neither here nor there. So she had both filed and both approved on her behalf. Both were filed as change of status cases. You're all getting goosebumps because this is like a ghost story. So both were approved under change of status. She had 2 approval notices that had I-94 cards attached that changed her status on October 1st. She decided in July, whoa, like, pull the brakes. I don't want to be on H-1B anymore. Like, she wants to be a single lady, right? She wants to have that freedom, right? So she's like, I gotta have my F1 back. Like, I need my F1 back. So, we advised her this, like, look, if you want your F1 back, you need to get your H-1Bs withdrawn on the record before October 1st. Because come October 1st, you are in H-1B status, and there's no going back after that. She was able to get one employer to withdraw. But remember, H-1Bs are employer petitions. If they don't want to withdraw, they don't have to withdraw. If they want to withdraw, they're supposed to withdraw if you're not working with them. If they don't do it properly, if they don't submit the documents, if they mail it to the wrong location, your case might not be withdrawn. And what ended up happening for her is that one of the H-1Bs was withdrawn, the other one was not withdrawn. She did not start working for the company on October 1st, and she fell out of status because her change of status, the H-1B change of status, went into effect and canceled her F1 record, but she was not maintaining H-1B status, because remember, you always have to look at what is your status to see how to maintain it. If you are an F1 student, you maintain your status by going to class and taking full-time course load and not working without authorization. If you are in post-completion, you maintain your status by working on OPT, reporting your employment to us, not going over your unemployment period, right? But if you're in H-1B, you maintain your status by working for the company that petitioned for your H-1B in the job, in the location, in the position that was filed for your H-1B. If you're not doing that, you're not maintaining your status. So, I mean, like horror story, right? Not made up to scare you, just made up to say the H-1B is like a runaway train. It's not easy to stop the brakes on it once it's been filed as a change of status in particular. It is possible, but we don't love it because it requires us to basically like handhold really, really aggressively, and like it requires you to like really doggedly communicate with the employer about withdrawing and getting copies of the withdrawal letters and monitoring the case status to make sure it's actually been withdrawn, and we have to correct your CVIS record and work with the government on that side. So, I mean, if you're not ready to commit, don't take the ring, I guess. We're just gonna go with like the engagement thing. Like, I mean, if you're not ready to commit, like don't have an H-1B change of status filed on your behalf. So that's kind of my thing. But more questions? More questions?
So during the H-1B filing to H-1B approval,
Yeah.
Can I change the company and tell the other company to carry away that H-1B to that company from?
So the question is, while your H-1B is pending, can you transfer it to another company? No. You can only transfer it if it's an approved H-1B. Yeah. Yes.
Even if it's in just approved status, but it hasn't yet kicked in, I think someone else asked this, but now that you mention it, it's just in approved status, it has not yet kicked in. Can another company still take it over?
Are you an immigration attorney? Are you a plant? So the question is, if you have like a consular H-1B approval notice that was never effectuated, that you never used, can you transfer it from one company to another? And the answer is, it depends on the attorney who's filing the case and their interpretation of the law. But usually, yes. There's not been clarification from the government about this particular issue. It is, I wouldn't say it's widely debated. I would say that it's kind of, people just kind of like discuss it in the field. But there are some people who interpret it to say that unless you used the H-1B, you cannot use it again for another employer, and that you would have to go through the lottery again. But I've worked at 3 different immigration firms, and I have friends that work at tons of other immigration firms, and I think my perspective is that the majority of attorneys would say that if you have an H-1B approved on your behalf, even if it's not effectuated, that it can transition to another employer. In the case of an H-1B change of status for consular processing that's filed on April 1st this year, let's say approved on July 1st this year, you can transfer it from Apple to Google, but you can't start working for Google until October 1st, because the validity date of October 1st won't change. But after October 1st, you can transition. More questions? Yes?
Is there an option to provide 2 addresses to your office location? Suppose the lease at the current location is expiring and the entire office is moving to a different location.
So the question is about like if my company's moving or if they have 2 offices. So in the case where they're moving, my recommendation would be sort of 1 of 2 things. 1, wait until they move to file your extension if possible. And if that's not possible, it's not a big deal. That's just a material change. You just need to submit a new I93. It's not a whole new application. It's just a new form that goes to our office and we keep it on file, and you keep it and the company keeps it. But it's not like you have to pay the government for a material change. And then there are other situations like, you know, if you work for a consulting company, what address do you put down? And that stuff is technical, and we'll talk about that in the workshops. But I hope that answers your question. Okay. More questions? Yeah.
Sorry. You mentioned like the random government visits.
Yeah.
What if you're not in office that day? I'm sure that's a bad thing.
So the question is about site visits. So the site visits are actually not aimed. So the question is, what if there's a random site visit and I happen to be on vacation that week? That's not so much what they're looking for. So the site visits are aimed at the employers, and they're looking at compliance of the employer. And so they're looking to make sure that when the employer says that they have enough personnel to supervise and manage you, that they actually have people to supervise and manage you. So if you work at a company and you're like on vacation, or you're getting, you know, you're at the dentist that morning, that's not that big of a deal. But if you work at a company and they show up and your company isn't actually in that building, or is there but the entire office is completely empty, they're looking for fraudsters, right? They're looking for, you know, the sketch consulting companies that like put people on their payroll but don't have them on their pay. I mean, we all know what they're looking for. They're looking for people that are actually breaking the law. They're not looking for, they're not going to gotcha Google and say, like, that guy's on vacation, yeah, right. Like, that's not really what they're there for. They're there just to make sure that they're in compliance. Yes, hello?
So reference to this question, I have heard that a couple of companies let you do work from home a couple of days just because of the computer and the facilities. And side by side, I have heard that when you are on OPT, that you are not supposed to work from home any day. So is it something that
Who told you you're not supposed to work from home on OPT?
one of the managers in the company?
So companies can have their own policies about stuff. You know, OPT is not tied to a work site in the sense that it's not like, there is nothing in OPT regulations that say that you cannot work from home a couple days a week, but you do need to be like working, and you need to be like actually doing things. But you know, I think a lot of people occasionally work from home, and if your company allows it, that's fine. I assume it would be the same on STEM, as long as it's properly, you know, reported in the training plan, and as long as it's not a benefit that others get that you don't get, or that others don't get that you do get, right? Like they can't say like, all international workers may work from home and all domestic workers must work from the office. Like it has to be, you know, even, and it can't be discriminatory. It is interesting and important to note that that is not necessarily the case for work visas. So work visas, like H-1Bs, are not just employer specific, but they're location specific. And so if you say that you're working in Menlo Park, you better be working in Menlo Park. And if you're not working in Menlo Park, you need to submit, you know, a change that says where you are working. So yes. So your company might just have a policy that says that international workers are not allowed to work from home to try to accommodate that situation, because you know your manager, especially if you're at a larger company, really shouldn't know like what your immigration status is. Like it's not something that, I mean, it's not that private, but like it's not something you should be talking about on a daily basis. And so some companies might just have a policy that says like, you know, no international workers work from home to try to accommodate the fact that they don't want their H-1Bs working from home, therefore, and they can't tell who is and is not H-1Bs unless they're in your personnel file or your immigration file.
So applies to both extension also. The same discussion applies to both OPT extensions, STEM extensions also, right?
Yeah, I mean, I would want to think about it a little more with regards to the STEM extension, and I'll certainly build something about work sites and work locations into the STEM workshop. But my kind of knee-jerk reaction, like off the top of my hat, is that I don't think working from home would be a problem as long as it's properly documented.
So reporting manager is fine with that, but the parallel manager had that comment, so I just wanted to make sure.
Well, and again, if your company has a policy, that's your company's policy, you need to follow your company's policy. Like, you like your company might say, everybody has to do yoga on Tuesday afternoons from 3 to 4, and like, you can either do yoga or you can not work there, I guess. I mean, so I think that like, if your company says no working from home, no working from home. If your company says yes working from home, you can work from home. Like, and I think that's kind of my perspective on it. Certainly with regards to OPT, I would have to think a little bit about the new STEM regulation, but I think, my final answer is also with the STEM regulation. Yeah. More questions? Yes?
Generally, how long does it take after you put in your application for the STEM extension till it actually gets approved?
So the typical processing time and the processing time that's allowed by law for OPT and STEM OPT both is 90 days. And they try to stick to that. By and large, they do a pretty good job sticking to it. Much better, frankly, on OPT than on other types of EAD cards that I've worked on. And so, I think that's good. And I think that they're trying to stick to it, and I think that they probably will stick to it. But remember, as long as your extension is filed properly before your current card expires, you are allowed to keep working. So even if it takes more than 90 days, even if your card expires, you are allowed to keep working as long as your extension was filed properly before your card expired. Any more questions? That's right. I tired you all out. Okay, well, thank you all for coming. I really appreciate it. And be on the lookout for the emails explaining when we're going to see you and when we're going to be working on your cases. And yeah, I'm going to turn this microphone off.